Good morning, students. Today we are going to start with the review session of Sale of Goods Act questions we have taken. To start with, let me just give you an introduction about Sale of Goods Act. Goods Act was introduced in the year 1930 with the objective of having a separate act for the contract of sale, and apparently you are supposed to know the definition of certain terms and meaning of contract of sale, how sale is distinguished from similar contracts like hire purchase, agreement to sell, etc., and what do you mean by formalities of contract of sales, and what is the subject matter of contract of sale, how to ascertain the price, and what is mean by condition and warranties, and how and what point of time the ownership in goods which are subject matter of the contract of sale passes to the buyer from the seller, and rules relating to the passing of property. And it is also obvious to know what is mean by unpaid seller, and you should analyze the effect of subsale or pledge by the buyer, and distinguish the right of lien and right of stoppage in transit, and understand the concept of sale by auction. It is also vital to know that the essentials of contract of sale are as follows. At least two parties must be there, and the subject matter of contract must necessarily be goods. The price in money should be paid or promised to be paid. The transfer of property in goods from seller to buyer must take place. The contract must be sale and it should be absolute or conditional. Other elements of valid contract must also be present in the contract of sale, because the contract of sale is still an extension of law of contract. Hence the essential elements of law of contract cannot be dispensed with. As regards to condition, it is the essential to the main purpose of the contract, but warranty is collateral to the main purpose of the contract. And also the aggrieved party can repudiate the contract or claim damages, or both, in case of breach of condition. But in case of breach of warranty, the aggrieved party can claim only damages. He cannot repudiate the contract. And also the breach of condition may be treated as breach of warranty, but breach of warranty cannot be treated as breach of condition. Also, there are certain express and implied conditions and warranties. Certain conditions which are implied to the contract of sale are condition as to title as envisaged in section 14 subsection A. Then you have sale by description, how to sell the product by description, that is, the buyer is not bound to accept and pay for goods which are not in accordance with the description of goods. Also, you have sale by sample, wherein the bulk should correspond with the sample, not only in quality, and the buyer shall have the reasonable opportunity of comparing the bulk with the sample. Also, the goods shall be free from any defect rendering them which cannot be sold, and also it cannot be apparent on reasonable examination of sample. Also, there is condition, implied condition of quality or fitness, which says that it is an if the goods are sold for particular purpose, and it is implied that the goods shall serve the purpose. Also, you have implied warranties, which says that warranty as to undisturbed possession, warranty as to non-existence of encumbrances, disclosure of dangerous nature of goods, and warranty as to quality or fitness by usage of trade. And we have another term called caveat emptor, which means let the buyer beware. That is, when a seller displays their goods in open market, it is for the buyers to make a proper selection or choice of goods. If the goods turn out to be defective, and he cannot hold the seller liable. But there are certain exceptions to this rule of caveat emptor, which are where the buyer makes known to the seller the particular purpose for which the goods are required, so as to show that he relies on seller's skill or judgment, and the goods are of a description which is in the course of seller's business to supply. It is the duty of seller to supply such goods which are reasonably fit for that purpose, which is envisaged in section 16.1. So we have certain exceptions to this rule of caveat emptor. And also we have the rules of passing the property, when and how the passing of property is made, which is covered under section 18 to section 24. Similarly, we have passing of risk, which is covered under section 26, and transfer of title, which is covered under section 27 to 30. There are certain rules regarding to delivery of goods covered under section 33 to 39, that is how delivery affects the sale, and who can apply for delivery, and what is the place of delivery, and what is the time of delivery, and how the delivery is been considered when the goods are lying with the third party. Then what do you mean by symbolic delivery, constructive delivery? All those are covered under this topic. Apart from that, we have one important topic called unpaid seller, wherein the rights of seller who has not been paid with this price is dealt in Sale of Goods Act. So accordingly, he has the right of lien, which is envisaged under section 47, right of stoppage in transit, then right of resale. Also, he has certain rights. Against these rights were against the right or against the right of goods, and we have right of unpaid seller against the buyer, which is a suit for price, suit for damages, repudiation of contract, and also suit for interest. So with this introduction, we can proceed to understand the review session. That is, we can proceed to solve the questions asked in the review session. Question number 1. Implied conditions include option A, condition as to title; option B, condition in case of sale by description; option C, condition in case of sale by sample; and option D, all of the above. The correct answer is option D, all of the above. The reason is implied conditions include the following: condition as to title, condition in case of sale by description, condition as to quality and fitness, condition as to merchantability, condition as to usage of trade or condition implied by custom, then condition as to wholesomeness, and condition as to sale by sample, and hence all of the above is the answer. Question number 2. The appropriation must be made by option A, the seller with the assent of buyer; option B, the buyer with the assent of seller; option C, the buyer or the seller with or without the assent of the other; option D, both A and B. The correct answer is option D, both A and B. Any appropriation by the seller must be made with the assent of the buyer, and any appropriation by the buyer must be made with the assent of the seller, and hence the answer is option D. Question number 3. A sells to B certain specific goods which are locked up in the godown. A gives B the key of godown. Option A, it is a delivery; option B, there is no delivery of goods; option C, it is a symbolic delivery; and option D, since the goods are locked up, there is no movement of goods to transfer possession. The correct answer is option C, it is a symbolic delivery. So when the goods are not physically delivered to the buyer but delivered by indicating or giving a symbol, the delivery is said to be symbolic. So the examples for these are delivery of the keys of the godown in which the goods are lying, then transfer of documents of the title of goods, etc. Question number 4. A stipulation which is collateral to the main purpose of the contract, and if proved false, gives the buyer only a right to claim damages, is known as dash. Option A, conditions; option B, guarantee; option C, warranty; and option D, none of the above. The correct answer is option C, warranty. Warranty is a stipulation which is collateral to the main purpose of contract, and if proved false, it gives the buyer the right to claim damages. So understanding the concept of warranty, the condition is something which is the main purpose of the contract, and warranty is parallel to the main purpose, that is, it is collateral to the main purpose of the contract. Example, when you contract to sell some goods, the main condition of the contract is to sell the goods, and collateral to the main condition can be transporting the goods at free of cost, that is the delivery, rules regarding the delivery. And hence if there is any breach of warranty, it gives the buyer the right only to claim damages and not to repudiate the contract, because it is not the main contract, it is just collateral to the main contract. Question number 5. A agrees to deliver his old car valued at rupees 80,000 to B, a car dealer, in exchange of a new car, and agrees to pay the difference in cash. It is option A, contract of sale; option B, agreement to sell; option C, exchange; option D, barter. The correct answer is option A, contract of sale. Under barter system, the goods are exchanged against goods. That is, there is no concept of price being involved in the barter system. No minor portion, that is not even a part of the contract includes price. The goods are exchanged for goods on the entirety. However, in the given question, there is a part of cash being involved in the contract, and hence it is not a barter system. It is a contract of sale. Also, it is also known that the contract of sale is a goods of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. So even part of consideration is by cash, it cannot be said as barter. Question number 6. The term goods means every kind of movable property other than actionable claims and money. The answer is, the options are option A true, option B partly true, option C false, option D partly false. The correct answer is false. Implied conditions include the following. That is, condition to title, condition in case of sale by description, condition as to quality and fitness, condition as to merchantability, condition as to usage of trade or customs implied by custom, condition as to wholesomeness, and condition as to sale by sample. And hence the actionable claims is not included in the implied claims. Also, it is obvious to know that the definition of goods also excludes actionable claims, and hence it includes only movable property, and therefore the option C is correct. Question number 7. Condition as to free from encumbrance is not an implied condition in the contract of sale. The options are A true, B false, C partly true, and D partly false. The correct answer is A true. As discussed, this is one of the implied condition, and hence it is self-explanatory. Question number 8. Rules for valid delivery of goods includes A. Payment of delivery of goods should be concurrent. B. Buyer should apply for delivery of goods. C. Expenses of delivery to be borne by the seller of goods. And D. All of the above. The correct answer is D. All of the above. The rules of the delivery of goods are the effect of part delivery, that is buyer to apply for goods, place of delivery, time of delivery, goods in possession of third party, expenses of delivery, that is to be borne by the seller, delivery of wrong quantity, and payment of delivery of goods should be concurrent, delivery of carrier, and deterioration of goods during transit, buyer's right to examine the goods. So these are the rules relating to delivery, and hence all the three rules are within the ambit of the said delivery, rules of delivery, and hence option D is correct. Answer to question number 9. Question number 9. In a contract through C, where the seller has to deliver the goods to the buyer at the port of destination, the contract is known as FOB contract, option B CIF contract, option C X ship contract, option D none of this. The correct answer is option B CIF contract. CIF means carriage, insurance, and freight, and FOB means free on board. The crucial difference between FOB and CIF agreement is the point at which responsibility and liability transfer from seller to buyer. With an FOB shipment, this occurs when the shipment reaches the port or other facility designated as point of origin. With a CIF agreement, the seller pays costs and assumes liability until the goods reach to the port of destination chosen by the buyer, and hence the correct answer is option B. Question number 10. An agreement to sell buyer dash goods on insolvency of seller. The options are A cannot claim, B can claim, C conditional claim, and D none of the above. The correct answer is option A. In an agreement to sell, the buyer cannot claim the goods on insolvency of seller because the actual sale has not effected. Question number 11. An unpaid seller has rights against the buyer personally. Options are to sue for the price, to sue for damages, to repudiate the contract, and all of the above. The correct answer is D, all of the above. The unpaid seller has the rights against the buyer personally to sue for the price, to sue for the damages, and also to sue for the contract, to repudiate the contract. Question number 12. The definition of unpaid seller is given in the Sale of Goods Act in option A section 45, B section 46, C section 47, and D section 48. The correct answer is A. The definition of unpaid seller is given under section 45 of Sale of Goods Act. Any stipulation in the contract of sale of goods that is essential for the main purpose of contract is known as option A guarantee, option B warranty, option C condition, and option D rule. The correct answer is option C condition. Any stipulation in contract of sale that is essential for main purpose of the contract is known as condition. Warranty is something which is collateral to the main purpose of the contract, and hence it is not the answer. Question number 14. Under section 19 of Sale of Goods Act 1930, the property in goods passes to the buyer. Option A on delivery of goods, option B when the parties intend the property in goods to pass, option C when the payment of price is made, option D when contract is made. The correct answer is option B when the parties intend the property in goods to pass. So under section 19, the Sale of Goods Act, the property in goods passes to the buyer when the parties intend the property in goods to pass. Question number 15. In a hire purchase agreement, A. The owner of goods pays the hire charges. B. The ownership is transferred to the hire purchaser when the seller pays the price for goods. Option C. The position of the hire purchasers is that to hire purchasers to that of bailey. Option D. The purchaser pays the price instantly. The correct answer is option C. The position of the hire purchaser to that of bailey. The other three options are the hire purchase, that is in hire purchase agreement the owner the purchaser becomes the owner only on payment of the last installment, and hence option B is wrong. And owner of the goods pays the hire charges. It is not the owner of the goods. The person who takes the goods on hire pays the hire charges, and hence option A is wrong. And option D, the purchaser pays the price instantly. It is not the purchaser who pays the price instantly. The purchaser pays the price only on installment basis, and hence he becomes the owner only after paying the last installment, and hence the option C is correct. Question number 16. Where the property in goods is to take place at future time, it is option A agreement to sell, option B sale, option C hire purchase agreement, and option D void. The correct answer is option A. Agreement to sell means where the property in goods is to take place at future time, and hence the option A is correct. Question number 17. A jus in personam means rights against a specific person. Option B the public at large. Option C a specific thing, and option D none of these. The correct answer is option A. Jus in personam means right against specific person. Question number 18. A sold a tin of disinfectant powder to K without warning, knowingly fully that if the tin was not opened with care, it will likely to cause injury. And K was injured while opening the tin. Which of the following statement is and correct? A is not liable to K under the doctrine of caveat emptor. A is liable for damages. A has no duty to disclose the facts to K. The buyer has responsibility to inquire about all the things before purchasing the goods. The correct answer is option B. A is liable for damages. The seller is responsible to disclose the dangerous nature of goods. This is an exception to the rule of caveat emptor, and hence the correct answer is option B. Question number 19. A directs B, who is a solicitor, to sell his estate by auction and to employ an auctioneer for this purpose. B names an auctioneer to conduct the sales. The status of C for the sale is option A, C is an agent of A. Option B, C is a subagent of A. Option C is an agent of B. And option D, C is neither an agent of A nor of B. The correct answer is C is an agent of A. An agent is a person employed to do any act for another or to represent another in dealings with the third person. The person for whom such act is done or who is so represented is called principal, and hence in this case C is obviously an agent of A. Question number 20. The right of stoppage in transit starts when the unpaid seller has parted with the goods, when the unpaid seller uses the goods, when the unpaid seller retains the possession of goods, and none of the above. The correct answer is option A, when unpaid seller has parted the goods. The right of stoppage in transit starts when the unpaid seller has parted the goods and he comes to know that the buyer is insolvent. Question number 21. Under the Sale of Goods Act, goods includes option A, immovable property, option B, actionable claims, option C, growing crops, option D, B and C above. The correct answer is option C, growing crops. This is because actionable claims and immovable property are specifically excluded from the definition of goods, and hence the correct answer is option C. Question number 22. An agreement to sell and sale is the same thing. Option A, true. Option B, partly true. Option C, false. And option D, partly false. The correct answer is option C, false. It is because agreement to sell is future contract and sale is a contract, and hence both of them are two different terms. Question number 23. X agrees to buy 100 liters of coconut oil from Y cisterns. It has many cisterns with more than 100 liters of oil in them. It is option A, sale, option B, agreement to sell, option C, bailment, and option D, hire purchase. The correct answer is agreement to sell. Where under a contract of sale, transfer of property in goods is to take place at the future time or subject to some condition thereafter to be fulfilled, the contract is called an agreement to sell, and hence the answer for this is also agreement to sell. Question number 24. In a hire purchase agreement, option A, an option is given to the hire purchaser to terminate the contract at any stage. Ownership is transferred to hire purchaser as soon as the contract is entered into. The hire purchaser is bound to pay the price when he uses the goods. And option D, none of the above. The correct answer is option A. The other three options, that is B, ownership is transferred to hire purchasers as soon as the contract is entered into. This we have already discussed. The ownership is transferred only at the end of, that is only on payment of the last installment, and hence this option is wrong. Then we come to option C, the hire purchaser is not bound to pay the price when he uses the goods. The hire purchases the person who purchases the goods on hire has to pay the installments, that is an agreed installments for using the goods, and hence option C is wrong. None of the above is anyway not the option, and hence option A is correct. Now we go to question number 25. A seller of goods is an unpaid seller when option A, a part of the goods, the part of the price of the goods has not been paid, the whole of the price of the goods has not been paid, nothing has been paid, either of the above. The correct answer is option D. So unpaid, section 45 says that unpaid seller is a person who is a seller of goods. If a seller of goods can be deemed to be unpaid seller if the goods when the whole of the price has not been paid or tendered, when the bill of exchange or other negotiable instrument has been received as conditional payment, and the condition for which it was received has not been fulfilled by reason of dishonor of the instrument or otherwise, and hence based on this definition it is understood that either of the above is the option. Question number 26. An agreement to sell is dash contract. Option A, executed contract. Option B, executory contract. Option C, implied contract. And option D, unilateral contract. The correct answer is option B. It's executory contract, because agreement to sell is a future contract and hence it is an executory contract. Question number 27. goods must be the same as wanted by the seller. This is option A, condition as to description, option B, condition as to sample, option C, condition as to wholesomeness, and option D, condition as to title. The correct answer is option A, condition as to description. So goods must be the same as wanted by the seller is a condition as to description. That is, whatever is being described by the buyer, the seller has to go along according to the description of the buyer, and he has to deliver the goods accordingly. When a buyer proves that he is solely dependent on the seller's knowledge and expertise for making the goods, and he describes his requirement, and hence the seller is supposed to go by the description and give the buyer the best goods according to his description. Question number 28. An unpaid seller having possession of the goods can exercise its right of lien. Option A, until the payment of whole price. Option B, until the payment of all costs and expenses. Option C, until the payment of price and expenses. And option D, in case stated in clauses B and C above. The correct answer is option A, until the payment of price. So hence, unpaid seller having the possession of goods can exercise his right of lien until the payment of price. Until the payment of cost and expenses is also included in price. That is, whatever the expenses the seller incurs and which is been agreed to be reimbursed by the buyer, it is also included in price. That is in option A, and hence the correct answer is option A. Question number 29. In a contract of sale, ordinarily there is dash as to quality or fitness for any purpose of goods. The options are an implied warranty or condition, an express warranty or condition, both A and B, and none of the above. The correct answer is option A. The major difference between condition and warranty is condition is the main purpose of the contract and warranty is collateral to the main purpose of the contract. And hence, in case of condition, both in case of condition and warranty, there is some implied warranty that the goods will be quality and it will fit the purpose for which it is being purchased, and hence there need not be any express agreement as regards to quality and fitness of the goods. The correct answer is option A. Question number 30. Dash under the Sale of Goods Act means goods identified in accordance with the agreement and after the contract of sale is made. Option A, the ascertained goods. Option B, contingent goods. Option C, unascertained goods. And option D, illegal goods. The correct option is option A. Ascertained goods under the Sale of Goods Act means goods identified in accordance with the agreement after the contract is made. Contingent goods are the one which will be made only on happening or non-happening of the goods. For example, A contracted to sell mangoes to B only if it rains. So it is selling of mangoes is highly dependent on the fact whether it is going to rain or not, and hence it is contingent goods. Unascertained goods are something which is not ascertained at the time of contract of sale, and hence it is not an option. And hence the correct answer is option A. Question number 31. A dentist agreed to supply a certain set of artificial teeth to patient. The material was wholly found by dentist. The contract was for option A, sale of goods, option B, contract for works and materials, option C, agreement to sell, and option D, hire purchase agreement. The correct answer is option A. This is because this is sale. This is a goods as within the purview of the definition of goods under the Sale of Goods Act. It is movable and hence it is goods, and the dentists have already agreed to supply a set of artificial teeth, and hence it is a sale of goods and not agreement to sell, because agreement to sell is something which is entered in future date, entered for the purpose of future date. Here the dentist has already agreed to supply a set of artificial teeth The only pending item is delivery of goods, so because of that it can't be considered as agreement to sell, and therefore the correct option is option A, sale of goods. 32. In case of sale by sample, there is an implied condition that option A, the bulk shall correspond with the sample in quality. The bulk cannot be compared with quantity. The goods shall be free from defect. Option D, both A and C. The correct answer is option A, the bulk shall correspond with sample in quality. Basically, sale by sample, this is one of the major condition which has to be complied with. That is, when sample is of A quality, then the bulk shall also be under A quality. Then only then the sale by sample is valid, and hence the correct option is option A. Question number 33. For a contract of sale, the essential element is option A, price, option B, agreement, option C, sale, and option D, none of this. The correct answer is option A, price. Price is the essential element of the sale of goods as per section 9. Agreement and sale are anyway the essential element for the contract as a whole, and hence for sale of goods, for sale, the essential element, the distinguishing essential element is price. Question number 34. Actual sale of future goods is option A, impossible, option B, possible through an agreement to sell, option C, illegal, and option D, myth. The correct answer is option B, possible through an agreement to sell. This is the major difference between agreement to sell and sale. Sale is something which happens at current date, but agreement to sell happens at future date. Question number 35. A agreed to exchange with B 100 quintals of barley at off per quarter for SS bullocks valued at F6 per lock, and pay the difference in cash. The contract was contract of sale. The contract was contract of exchange. The contract was an agreement to sell, and option D, none of the above. The correct answer is the contract was contract of sale. That is option B, big option A. This is because it is entered for a current date, and hence it is contract of sale, and paying the difference in cash is a different scenario. That is, it is a payment part, not the agreement part. Hence this can't be said as agreement to sell. Question number 36. Section 24 of Sale of Goods Act 1930 deals with passing of property in goods where goods are sent. A, on approval, B, on sale or return basis, C, in installments, D, A and B. The correct answer is D, A and B. In both the cases, on approval and sale or return basis, it deals with, that is, the passing of property is the passing of property in goods is dealt with. So according to section 24, both the on approval and return basis, it deals with passing of property where the goods are sent on approval and on return or sale basis. Question number 37. The term unpaid seller includes seller's agents to whom the bill of lading is endorsed, buyer's agent to whom the bill of lading is endorsed, buyer's agent to whom the goods have been delivered, seller's agent to whom the goods have been delivered. So the correct answer is option A. The term unpaid seller includes seller's agent to whom the bill of lading is endorsed. Question number 38. The action of goods being physically delivered to the buyer is known as actual delivery, constructive delivery, symbolic delivery, and option D, all of the above. The correct answer is actual delivery. Symbolic delivery and constructive delivery are different terms. As discussed, symbolic delivery is something which which is a symbol of delivery and not an actual delivery. Example, giving a key of a car to a person means that he has delivered the car, so that is a symbol. So it is different from actual delivery, and hence the correct answer is actual delivery. Question number 39. X sells and consigns certain goods to Y, assigns bill of lading for these goods to Z to secure the sum of rupees 5,000 due from him to Z. Y becomes insolvent. Option A, X can stop the goods in transit. Option B, X cannot stop the goods in transit. Option C, X can claim against Y and Z. And option D, none of the above. The correct answer is option A. X can stop the goods in transit. This is because in this case, as the question contains, the X sells and consigns certain goods to Y, who assigns the bill of lading for these goods to Z to secure the sum of rupees 1000 due from him to Y, and Y becomes insolvent. Now X has the right to stop the goods in transit, because though it is assigned to Z, here Y becomes insolvent, and hence X has the charge against Y, and hence X has the right to stop the goods in transit. Deliverable state is defined in section 2 subsection 1, section 2 subsection 2, section 2 subsection 3, and section 2 subsection 4. The correct answer is C, section 2 subsection 3. This is self-explanatory. Condition as to quality or fitness is given to sale of goods act under section 16 subsection 1, section 16 subsection 2, section 16 subsection 3, and section 16 subsection 4. The correct answer is section 16 subsection 1. This is also self-explanatory. Question number 42. Once possession is lost, right of lien of unpaid seller is also lost. This statement is option A true, option B false, option C partly true, and option D partly false. The correct answer is option A true. So once the possession is lost, right of lien of unpaid seller is also lost. The right of lien, the basis for right of lien is possessing the goods. That is, if you possess the goods, you have the right to lien. So hence the right of possession is also lost. Consequently, the right of lien should also lose, and hence the correct answer is option A. Question number 43. The stipulation in a contract of sale of goods, breach of which gives right to claim damages, is called option A guarantee, option B warranty, option C condition, and option D security. The correct answer is option B warranty. So here it is a stipulation in a contract of sale of goods, breach of which gives right to claim damages. As discussed, breach against the condition of a contract will give the right to repudiate the contract and also claim the damages. But in this question, the right is only to claim the damages, and hence it is obviously the breach of warranty. Question number 44. In case of breach of warranty, the aggrieved party can repudiate the contract, B treat the contract as voidable, option C claim damages only, option D can treat it as breach of warranty. The correct answer is claim damage only. This is also already discussed. In case of breach of warranty, the seller has the claim. The buyer has the right to claim damage only. He cannot repudiate the contract against the seller. It is only in case of breach of condition the right to repudiate the contract exists. Question number 45. The principle of caveat emptor is given in the Sale of Goods Act 1930 under option A section 18, option B section 17, option C section 16, and option D section 15. The correct answer is option C section 16. This is self-explanatory. So with this we have completed the review of Sale of Goods Act. Should you have any queries, kindly mail to queries@greymatteracademics.com. Thank you.